Okay, so I think we're live. And I just wanted to do a really quick late night video addressing recent Supreme Court decision. And for those of you who don't know, the the judgment essentially declared that the 1964 Civil Rights Act applied not only to the not only it was applicable not only on the basis of sex but also sexual orientation and gender identity. So it applied to transgender individuals. Hi, Correns. Okay, see, some people are up at this hour of the night, which is good. Uh, so gender identity. So men who believe that they were born into the wrong body and are actually women, and vice versa. These legal protections apply to them as well. And it's really interesting when you look at the underlying case, you see how bizarre our legal system has become. So the petitioner in one of the cases was actually a transgender woman, a man identifying as a woman who worked at a funeral parlor. And he was tasked with talking to grieving families after their loved ones had died. And it's really quite bizarre, even if you believe in transgender rights, to to assume that someone is entitled to a job which might discomfort people who are at their most vulnerable moment is kind of, it's kind of a stretch. I mean, it's essentially saying that that your priorities or your emotional state should supplant those of your clientele, even if they're incredibly vulnerable and really at their most at their lowest point. People who just experienced the passing of a brother or uncle or beloved child. And it kind of ties into the whole movement to insert transgender athletes into competitive female sports. So the most recent case you may be aware of was the was the girls track team in Connecticut, where a biological quote unquote girl sued in order to redress a wrong, which was that the three winners of a track meet in that state or that city were all biological men who identified as girls. And it's it kind of illustrates the problems you have when you have this emphasis on uh, for lack of a better term, diversity. You have such a prioritization of people's desires and wishes, even if those impede upon other people's goals, and there's no real way to reconcile them. Because here you have the goals of feminism, which initially were to advance opportunities for women. So you have things like Title IX and female only sports, trying to give women opportunities that they had been denied in previous generations. And this comes into direct conflict with this need of a new kind of sort of fabricated social group. i.e., transgender individuals, to to place their emotional state above any of the ambitions of girls or women who are trying to succeed in things like intramural athletics. And you can't really reconcile these two forces. There has to be a decision made on behalf of one or the other. And that's the problem you have when you have a culture that's being driven by the most vociferous and the most militant and the most novel, the most new faction, left-wing faction. So in the past, it might have been third wave feminists or gay, gay and lesbian activists, but now it's transgender activists. So their goals have to face any any other group that might have been part of this liberal coalition. Um, and it really is a paradox that I don't think the left in this country can entirely resolve without this descending into internecine battles across the country. And there's really no way to reconcile all of these competing factions. And the problem with the Supreme Court decision wasn't so much judicial activism per se, or jurists kind of freelancing, even though I think the judiciary has become um, one of the most aggressive, or the most aggressive branches in arrogating to itself powers that don't belong to it, that aren't enumerated in the Constitution. For example, when the Civil Rights Act was passed, there was no intention, there was no intention of extending it to extending it beyond sex, beyond women. And the irony here is, for those of you who don't know the history of the Civil Rights Act, it was something that had been worked on in the Kennedy administration, and of course Lyndon Johnson, a very powerful Southern Texan Democrat, was able to use his political capital to shepherd it through Congress and to enact it into law. But it was intended originally just to address the grievances of Black Americans, the racial discrimination encoded into law. But sex was added to it in order to the category of sex was added to it in order to derail the bill. It was actually This was something that was proposed by Strom Thurmond, a Dixiecrat, a hardcore segregationist at the time, who wanted to, and he actually, I believe he filibustered the bill, but he and some other members of Congress who wanted to thwart this bill, wanted to prevent it from becoming law, added sex to it because they thought this would just scotch the entire bill. Okay, maybe if we were extending rights to Black Americans, that had enough support in order to be enacted into law. But if we included women, it would present a logjam that would stop it from passing. Well, of course, the irony is that it didn't. It just it was just included into the bill, into the eventual law, the Civil Rights Act. So the law itself is, and the scope of it is the problem, not so much the judiciary's interpretation or misinterpretation of it. Now, when people think of the Civil Rights Act, they think of legislative, the national legislature, Congress, abolishing public racial discrimination. They think of things like black codes or Jim Crow laws. Now, the thing about these laws was these were laws that did not um, uh, these were laws that prevented businesses from serving um, serving uh, black uh, a black clientele and customers, and imposed artificially segregated the races. So in other words, it wasn't so much a grassroots demand, even though there was widespread support in many states for segregation, but rather it was kind of a top down edict. These laws wouldn't allow you to serve black customers if you were a restaurant, say, or a company that wanted to serve black customers along with white customers. To if you wanted to simply um, serve your customers in a non-discriminatory way, you were prevented from doing it. So, and this is something that libertarians, uh, at least ideologically consistent ones, will bring up: the fact that these laws, Jim Crow laws, all of these laws, they were designed to prevent people from uh, from basically pursuing their own best interest uh, as entrepreneurs or businessmen. So you weren't allowed to serve an interracial clientele. You were prevented from doing it. It wasn't as if in other words, it was basically a government edict. And a lot of people assumed that the Civil Rights Act was simply meant to address that, to do away with these laws that discriminated against Black Americans and prevented them from um, accessing uh, services and capital that they would otherwise have access to. When in fact, it went much further than that, and it basically said, and instituted into law, the fact that you could not discriminate against anyone, um, whether you were public, whether you were a private business, or whether you were a public institution, a government institution like the public schools or the police force or the fire department. It basically extended to any sort of business. It went beyond ending public discrimination, racial discrimination, and said any business whatsoever, you're not allowed to discriminate. Now, Thomas Sowell is an African American economist, and he's written some great books that actually explore the underlying basis for discrimination and look at the economics of discrimination, racial discrimination, and if you read his work, you understand that in a capitalist or free market society, discriminating against a certain group of people because of in an arbitrary fashion is not beneficial to you, which is why most businesses will not do this. And Walter Williams has pointed this out as well. In South Africa, they actually had to impose laws to prevent businesses from um, people from doing business with Black South Africans, white-owned businesses. They had to enact laws to prevent that from happening because it was profitable to those businesses. And this is something similar. A similar principle applies in the case of the United States with something like the Civil Rights Act. A business that goes out of its way to discriminate against potential customers based on arbitrary measures or things like skin color they're actually harming themselves. You don't need the federal government to come in and mandate that those businesses serve serve a more diverse clientele. They'll actually, if a business operates that way, using arbitrary, um, taking arbitrary things like skin color or sex or what have you, using those metrics as a way to um, deny customers access to the business. Hi, Michelle. Hi, GW. Hi, Christine. That business will not succeed in the long run. And another problem with this is often when you have these laws, people who are intent on discriminating will simply do it in a much more subtle and insidious fashion. So that you're not really achieving what you hope to achieve. If the goal is to eliminate racism or eliminate racial discrimination, you're simply channeling this into um, less accessible or less measurable parts. You're not really accomplishing what you set out to accomplish, but also it's not constitutional. If you look at the Constitution, you're essentially interposing the government and telling it into commerce, private commerce, companies that want to decide for themselves how they should conduct business. You're interposing the government into that decision making process in the same way that states that enacted Jim Crow laws or black codes would insert themselves into the process in order to achieve their own ends. Now, in the former case, it's ostensibly to achieve these noble goals of ending discrimination. In the latter, it's to reify racial discrimination, but I don't think either is constitutional, and they both cut against the foundation of this country, which is property rights, being able to. It's it really is a violation of the takings clause. If you examine laws like the 1964 Civil Rights Act, it really is a violation of the takings clause. Now, of course, that clause of our Constitution is kind of a dead letter, even as other parts of the Constitution are continually expanded and embroidered upon and used by justices who believe that the Constitution is this living document that they can kind of use it as a Mad Libs to achieve whatever social policy they desire, whatever public policy they want to see enacted. But if you look at the Constitution and read it and don't impose your own socio-political or economic views onto that document, most of the judicial legislating that we've seen over the past century would be would be erased. I mean, it would completely not stand. And what you're seeing now, where you have the Civil Rights Act being used to advance the cause of transgender activism or LGBT activism and force employers to retain someone indefinitely if they fall under specific rubrics of what we call protected classes. What you're seeing now, this is just the beginning of a never-ending process, which essentially strips private businesses of the right to make any independent decisions on their own. It's not a good place to be in when you think about it, and it's definitely not an encouragement to people who want to own their own businesses or want to be entrepreneurs. It's really it's really insidious when you project out what's going to happen, or what possibly could happen if we use these if we use this type of reasoning. It's just really, uh, really bad. So even at the time, the 1964 Civil Rights Act, it looked like a very good thing. It ended public discrimination, but it also set in motion this chain of events which erased any sort of autonomy you could have as an independent, um, owner of a business or entrepreneur. It limited property rights, and there were a lot of ways to address racial discrimination without going down this path, which ultimately is not really about racism or tackling racism. It's about exercising power and authority. And I think that's been the motivation of a lot of the political, energy we've seen that's dominated the culture and the politics of this country over the past 60 or 70 years. Yeah, Barry Goldwater, um, warned about this, and yeah, it really was easy to foresee some of the to foresee the general path that this would come down to, where you would not be you would not be allowed to make a decision that would reflect badly on not just, we've seen it's expanded not just, in terms of race or sex, but now sexual orientation or gender identity. And the question is, where is the end point? Where's the end of the line? And what's the apotheosis of this? Like, will you not be able to fire people who are criminals, hardened criminals, who are, who've committed grand larceny, or like what's the line? Basically, it's saying that you can't discriminate based on any objective criteria. It really is amazing, and there are moves in places like New York City and elsewhere to prevent employers from not hiring criminals or ex-convicts, which it's not. Again, the way it's presented is as something to reintegrate people who have committed a crime, and it's theoretically it sounds like a a a noble endeavor. But when you actually examine it and figure out what's going to happen if you impose these rules on businesses, it's not going to redound to the benefit of the group that's being championed, and it's going to make it even more difficult for people to be hired. It's really it's it's just bad. I mean, people don't see this because they've kind of exalted the idea of tolerance and diversity, and, they think that this is that eliminating any sort of bigoted or racist thought is an achievable goal, and that you can achieve that through legislative and judicial lawmaking, which is not true. But what has happened while you've aimed for this is concrete kind of bedrock American values like property rights and freedom of association. These things have been completely trampled upon. And I think that's what you're going to see in the future. So, I mean, yes, you can criticize Neil Gorsuch and the other five members of the Supreme Court, and I think they are worthy of criticism. but I think this speaks to a much broader issue when you actually examine it, and a much bigger problem that goes the beyond judicial activism per se. It's kind of a defect in the political character and the way these types of issues are presented to the public. Anyway, thanks everyone, Alejandro, Scott, John, everyone that came. Glad that you're tuning in, and I will see you next time.